provide reasons for the same. I thank you, Honorable Speaker.
Honorable CS, you may now proceed to respond.
Thank you, Mr. Speaker. I beg to answer the question. I will have to go through the journey, take you through the journey of the new KCC for the House to actually grasp where we are. Our response as a ministry, the origin of the Kenya Cooperatives Creameries Limited, KCC Limited, dates back to 22nd August 1925, when it was incorporated as a limited liability company. Later, on 8th February 1932, it was registered as a cooperative society, whereby it ran its operation until the year 1999, when it was then placed under receivership by the Kenya Commercial Bank, who was its debenture holder. In the year 2000, private individuals incorporated KCC 2000 Limited and acquired KCC business through bids invited by the receiver manager then, PricewaterhouseCoopers. KCC was liquidated. Therefore, it ceased to exist as a cooperative society nor a party corporate, since it was sold off to KCC 2000 Limited, which was a private company. On 6 June 2003, following a cabinet approval, the government of the Republic of Kenya bought back all the assets that had been sold to the KCC 2000 Limited. On 19th November 2004, new KCC was incorporated as a limited liability company with 100% government shareholding, thus converting its status to a state corporation under certificate number C11 353-8. In the year 1988, during the subsistence of KCC Limited, the claimants above filed an industrial case, number 24 of 1988, wherein they had sued KCC Limited, following termination of their employment after a strike had been called by the union. The matter was heard, and the court made a ruling that KCC Limited was liable to pay them. However, KCC Limited had collapsed, went into liquidation, and subsequently wound up and ceased to exist by the Kenya Gazette notice of 4th March 2003. At the time the claimants were filing the suit in the year 1988, new KCC Limited was not in existence and therefore was not a party to the suit. Similarly, new KCC Limited, having not been in existence when the claimants were in employment, it was clearly not their employer. The said claimants were employees of KCC Limited and not new KCC Limited, thus cannot be compensated by an organization they did not work for. New KCC Limited and KCC Limited cannot be said to be one and the same in law. However, a vesting order that was subsequently issued on 15th November 2005 was vested free from all encumbrances. That in accordance with the Transfer of Business Act, Section 3, a public notice was done and was printed in the Daily Nation on 28 June 2005 in regard to the government's purchasing the business and assets of KCC 2000 Limited. The employees did not object the notice to claim their dues as is required by the law, and thus Section 8 of the same Act came into effect that a claimant cannot institute a claim in respect of any liability upon expiry of 6 months. In the year 2013, the claimants filed a suit, Nairobi number 1299, 2013, John Kihato, Barrow, and 108 others, versus New KCC Limited and the Attorney General, seeking to be paid a sum of 204,417,555.50 Kenya shillings at the High Court. The matter was heard and concluded, and the High Court made a ruling that New KCC Limited was liable to pay KCC Limited former employees' dues. Subsequently, New KCC Limited filed an appeal against the High Court decision at the Court of Appeal under Civil Appeal number 191 of 2018. A three-judge bench on 10th July 2020 held that New KCC was not liable for the liability of KCC Limited, which included the terminal benefits and unpaid SACCO shares of the said claimants. However, notwithstanding the above, and absolving of the New KCC Limited from the said liabilities, in accordance with the law that the appellate judges implored upon the Attorney General's office, verbatim, having said so, however, and legalities aside, we hold on to the hope that the Attorney General will find it in her to advise government to honor its word and pay the first respondents who have suffered long. In view of the above comment by the appellant judges, my ministry wrote to the Attorney General seeking an advisory on the same. In a letter dated 3rd October 2024, reference number AG CONF/6B/18-2, the Attorney General provided an advisory, made several recommendations, including, number one, formation of an interministerial committee consisting of the Ministry of Agriculture and Livestock, the Ministry of Cooperatives and MSME Development, and the National Treasury to look into the matter and resolve the issue with finality. The committee should be tasked to collect, audit, verify, authenticate, and validate the claims and recommend whether the same should be settled and to what extent within reasonable timelines. That upon conclusion of its work, the petitioners should be engaged in out-of-court settlement within with a view of finding an amicable solution to the impasse and notification of the outcome to be done to the Senate. My ministry has already written to the Treasury, the Ministry of Agriculture and Livestock Development, to nominate suitable officers to implement the Attorney General's advisory. When the committee is constituted and completes its work, the recommendation thereof will be communicated to the Senate. For question number B, when can the affected former employees be expected to receive their terminal dues? My response, Mr. Speaker, sir, the former employees may be paid once the Interministerial Committee completes its work and recommends payment and National Assembly appropriates the required funds in the national budget. On the last question, could the Cabinet Secretary also indicate whether the former employees have received payment for their cooperative society shares they held as at the time of the exit from KCC, and if not, provide reasons for the same? My response, Mr. Speaker, sir, is that I'm not aware of any complaints on payment of cooperative shares held by the time KCC Limited was liquidated. I, however, am aware of claims of funds deducted from the then employees' salaries that had not been remitted in their cooperative society in respect of their shares. This amount is being considered together with other employment dues as explained in the above response. Thank you, Mr. Speaker.
Honorable Betty Akinyi, you may now ask your two supplementary questions.
Thank you, Mr. Speaker, sir. Once more, my two supplementary questions are, Honorable CS, do you have an inventory of these former employees? And if so, how many? You have seen, you've described them as have suffered for so long. And so do you know how many they are and what are the timelines of the finalities you talk about in terms of the interministerial committee work